I recently watched a video on YouTube with Randy Bundy, who's the son of Cliven Bundy. He gave their reason for why they believe the land in question does not belong to the federal government. He does not claim that the Bundys own the land. He claims it's either owned by the state of Nevada or Clark County, Nevada. He cites Article 1, Section 8, Clause 17 of the Constitution, also referring to Article 10 of the Bill of Rights. He indicates that by that, Congress is limited to doing only those things that are allowed for Congress to do in Article 1, Section 8. This position makes absolutely no sense, particularly if you look at the Bill of Rights. There is no reason to have the First Amendment or the Second Amendment. The reason for that is Article 1, Section 8 does not give Congress the right to establish a religion, to restrict the citizens' ability to petition the government, does not give it the ability to limit freedom of speech, does not give it the ability to limit freedom of press, nor does it give it the right to limit freedom of association. Similarly, Article 1, Section 8 does not give the Congress power to regulate firearms. Therefore, if his contention is right, then there's no reasons for Article 1 or Article 2 of the Bill of Rights. And then we should actually read what Article 1, Section 8, Clause 17 says. It says, to exercise exclusive legislative in all cases whatsoever over such district not exceeding 10 miles square as may by cession of a particular state and the acceptance of Congress become the seat of government of the United States. So what that part says essentially is the federal government can set up a district to have the seat of government, and it will be able to exercise exclusive legislation in all cases whatsoever. That means that since Washington, D.C. was taken from Maryland and Virginia, those two states could not pass laws in the District of Columbia. Then it goes on to say, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Again, looking at the plain meaning, it says, and to exercise like authority. Like authority, the only thing it can refer to is the right to exercise exclusive legislation in all cases whatsoever. Therefore, this whole thing means that if the federal government bought some land and they decided to put up a fort or magazine or arsenal on it, they could, if the legislature of the state allowed for it, make it so they would have the exclusive right to legislate. And if they don't do that, then the state's laws would apply on the federal land. An example of this, and I went to the internet and tried to find out cases on it, and I did find a site at the University of Chicago Law School. The newest case dealing with this clause is from 1834. There is a case that somewhat deals with the issues of this. In particular, it was People versus Godfrey, Mr. Godfrey apparently committed a crime. He committed the crime while at Fort Niagara, and he tried to claim that because he was on federal land, he could not be charged in the state court, and the Supreme Court found that the United States did not have exclusive jurisdiction, and therefore he could also be tried in state court. So if you just look at the plain meanings of the words in this statute, and that's why it's not been litigated, the limitation is to exercise like authority over places purchased. That means to have the exclusive legislative right, and therefore the claim that this Article 1, Section 8, Clause 17 limits what land the federal government can own makes absolutely no sense.